Welcome, I'm Jim Falk. No other American president in recent history has been more determined than Donald Trump to amass power, testing the ability of the judicial branch to rein in the executive branch, the White House. To date, Congress has shown neither the intent or ability to exercise its constitutional power. Recognizing the corrupt nature of unchecked power, the founders and writers of the Constitution designed a system of government with co-equal branches, creating a system that we know well of checks and balances. Now, today we are joined by two experts who have given considerable thought to the role of the president and to the wider issues of executive power, which, if left unchecked, what that might mean for our republic. Jeremi Suri is a frequent guest of the program. He's a presidential historian at the University of Texas at Austin, where he is the Mack Brown Distinguished Professor for Global Leadership, History, and Public Policy. He's the author of at least 9 books on contemporary politics and foreign policy, and he and his son Zachary host a really great podcast, This is Democracy. They also publish together a weekly newsletter on Substack titled Democracy of Hope. Stephen Vladeck is a professor of law at the Georgetown University School of Law, and he's a nationally recognized expert on the federal courts and the Supreme Court. He's a CNN Supreme Court analyst and editor and author of the book called The Shadow Docket, How the Supreme Court Uses Stealth Rulings to Amass Power and Undermine the Republic. He, like Jeremi Suri, has a twice-weekly Substack newsletter. Its title is One First, where he writes about, it won't surprise you, the Supreme Court. Welcome to both of you. Thanks for being here.
Thanks for having us.
So this may sound a little bit like a political science class, but I don't think it's Poli-Sci 101 because we're going to go a little bit farther. But Stephen, what is the unitary executive theory?
Sure. So the unitary executive theory is just that. It is a vision of the president's constitutional powers that really was first given voice in the academy. And at its simplest, it basically stands for the idea that because the vesting clause of Article 2 of the Constitution, which says the executive power of the United States shall be vested in a president of the United States, because it vests the executive power in the president, Jim, the theory is that it must follow that the president's entitled to complete and indefeasible control over the entire executive branch. You can't have independent agencies. You can't have civil servants. You can't have anyone anywhere in the executive branch who is not subject to the president's direct, immediate, and in some cases constant political control, because the president has to be the unitary head of the executive branch.
So, Jeremi, what was the founders' intent? And clearly government was a lot simpler back when the Constitution was written.
Well, their intent was the opposite of the theory that Steve just described. They never used those words. There's not a single case where they talk about a unitary executive. What they wanted was actually a very small presidency. I've written a lot about this. Other historians have too. They expected the president to actually be less powerful than Congress, and they expected that presidents would play the major role that they would play during a time of war or a time of emergency. And even then, they expected the president to really be subservient to Congress. For James Madison in particular, the legislature was to be the supreme body within the United States. And for that reason, they gave the president no budget. They gave the president no staff. And George Washington, our first president, did a lot to unify the country. But most of that was actually his traveling around the country, meeting and talking with people. It was not legislating from the executive branch.
So, I guess we could go way back in history, but I'd like to perhaps just sort of set a date and say 1974, or with the Nixon maybe going to 68. Can you look at that recent history and say when there was more emphasis on this, and can you also tie it to Republican or Democratic administrations? And I think I'll ask both of you that question and start with Stephen.
I think Nixon is the right place to look. There were claims of broader executive power than we had seen historically, as far back as World War II, when President Roosevelt had some especially compelling circumstances in which to argue for presidential powers. But you really don't see claims that, for example, various statutes were unconstitutional insofar as they interfered with the president's control of the executive branch until you get to Nixon. And those claims are, in some respects, products of the Justice Department's Office of Legal Counsel, which was run for a time by William H. Rehnquist, which was run not long thereafter by Antonin Scalia. But these were in some respects, the first movers for the notion that there were circumstances in which Congress could impose constraints on the president that would be unconstitutional, even though they did not violate any specific provision of the Constitution. It's the first time you see that in more than a scattershot context is absolutely during the Nixon administration.
Jeremy, would you add to that? Give your thoughts.
Yeah, sure. So Steve's absolutely right that Nixon is the first president to make a systematic argument for that. But the scattershot analogy works well. There were many presidents who at particular moments made claims, but they always denied that they were making a standardized claim. They said it was context and issue specific. So Andrew Jackson certainly challenged Henry Clay and Congress on a few occasions, but he did not systematically challenge Congress's right to set law. Andrew Johnson, as president, went in the face of a whole series of Reconstruction pieces of legislation. But in his case, again, he was claiming that those particular pieces of legislation were not appropriate. He was not challenging Congress's authority. And then Franklin Roosevelt never directly challenged Congress's authority, but often went ahead disregarding Congress or selectively interpreting what Congress had done. But the point here is that those were the exceptions to the rule, and none of them made the case that Nixon began to make, that the president somehow had a superior executive authority over congressional restrictions on executive uses of power.
I think we'll all agree that Congress has not exerted its oversight, its power. What do you think is the cause of that?
I think there are many reasons why members of Congress over the last 30 to 40 years have been bashful about challenging the executive. They certainly were not bashful in the early 1970s. And I think it's a variety of campaign pressures, but also Supreme Court decisions. I'm going to leave the Supreme Court decisions to Steve. In terms of political pressures, one of the things that's happened is that there's been a massive infusion of money into our politics, and the leader of the party is often the person in the White House who can dole out money. And so there's a concern about challenging the leadership of the party, which would challenge one's fundraising capabilities. And so it is the control of funds by the president, as much as anything else, that gives the president control over Congress.
I would just add, I think that's all exactly right. But there's one other factor, which is, the polarization of Congress and especially the House. There's a remarkable graphic that plots out every member of the House in each Congress going back to World War II. And, throughout the 50s, 60s, and 70s, you had a slew of liberal Republicans and conservative Democrats, exactly the kinds of members who would cross over. So you'd have bipartisan majorities, to assert Congress's institutional interests. It's how you get all of the post-Watergate statutes that, really do try to reorient the separation of powers. But, by the mid-1980s, the early 1990s, because of some of the forces Jeremy identified, because of the rise of severe partisan gerrymandering, we get to a point where primary elections become much more important for the majority of seats in the House of Representatives than the general election. And, when you're running in a primary, when that's your principal obstacle, you're going to run to your base. And, you run to your base not by asserting institutional objections against a president who might even be of the same party. You run to your base by, looking for the most visible, colorful, attractive candy. And I think that's, you add those forces together and you add the Supreme Court's refusal to rein that in, especially in the 2019 decision in Arucho versus Common Cause. You add the Supreme Court's blessing of, almost limitless amounts of dark money in political races in Citizens United. And I think, you get this result for better. And some folks may think it's a constitutionally mandated result, but whether it is or not, the result is that it is no longer the case that people run for Congress on institutionalist terms versus on very heavily partisan infused ideas. We really do have a separation of parties in Washington, not a separation of powers.
That one thing that needs to be said is that what the Supreme Court has rubber stamped, in my view, in the last few years is presidential behavior that even personally imperils members of Congress, right? If the president is immune from prosecution, and if it's harder and harder to hold the president accountable to the basic laws that all of us have to operate with in our professional lives, it sends a message that the president can, and the president's advisors and minions can go out and threaten members of Congress. And we've now had multiple members of Congress, most recently Senator Lisa Murkowski, commenting on the ways in which she and other members feel personally threatened if they cross the president of the United States. Now, Richard Nixon made verbal threats to people all the time. We've heard the recordings. But part of what happened with Watergate was the president was reined in. The Supreme Court said the president couldn't hold on to evidence that he wanted to hold on to, claiming executive privilege. And then Congress went and instituted a number of restrictions on presidential behavior. And that, I think, sent a message to presidents for a while that they had to not threaten members of Congress. We've gone to the other extreme now.
Yeah, I mean, I think there are a couple of different things going on. So, the impoundment issue is arising in cases like the USAID case where the president's taking money Congress has already appropriated and just refusing to spend it. And that's not a close question as to whether that's legal. I mean, most of the litigation has really been fighting over procedural questions about who's the right party to sue and where do they sue. Congress passed a statute in 1974 called the Impoundment Control Act that provides a vehicle for the president to try to do what Trump is trying to do. He hasn't tried it. The president hasn't gone to Congress and asked them to reform the Impoundment Control Act. He's just unilaterally arrogating Congress's appropriations power, its most important power. But, Jim, I would throw into the impoundment context also all of the unilateral moves Trump is making to cancel grants that have been approved by Congress, that have been appropriated by Congress. The effort to impose conditions on the recipients of federal money that are not authorized by statute. So, for example, telling universities what they have to do from a governance perspective in order to not have, hundreds of millions of dollars of research money cut off. There's no serious argument that the president has the legal authority to do that. And so one of the problems we've confronted that I think is novel in the separation of power space is not sort of novel claims of legality, but novel degrees of unlawful activity that have, in some respects, confounded and frustrated the ability of our ordinary processes to check them and to push back against them. And here again, I think Congress is part of the story. I mean, one of the most remarkable quotes of President Trump's first 100 days, I think, has to be the quote from Tom Cole, who is a Republican congressman from Oklahoma who just happens to also be the chair of the House Appropriations Committee. And Tom Cole, the most important congressional appropriator, said there's nothing wrong with what Trump's doing because appropriations aren't even laws. Like the extent to which that just fails basic understandings of what laws are and what Congress's responsibility is, I think really speaks to how we got to where we are. And Jim speaks to why these cases have been difficult. Historically, the reasons why presidents would never dare to try to arrogate so much of Congress's spending power is because Congress would push back. And with Congress not pushing back, we're left to unprecedented litigation over just how much the president can do the novel things he's trying to do. It's part of why we're seeing such a flurry of litigation behavior in the federal courts. And, I think we're seeing, Jim, in the day-to-day headlines, some of the consequences of that abdication, where we're seeing, senior cabinet leaders, folks like Secretary Hegseth or Secretary Noem, regularly engaging in behavior that just reinforces how they should never have been confirmed for these really important, really senior positions in the first place. Some of that, of course, is the president's fault for picking them. But, the Constitution, just to get back to the separation of powers for a second, gives the Senate the advice and consent function, at least largely to temper those impulses. And, if the Senate's not going to actually exert that authority and is not going to use it as a lever, then what's to stop presidents of both parties from picking, completely incompetent people who just happen to be very personally loyal to them to run these very serious, very important government agencies?
And Steve, you mentioned a few minutes ago the Office of Legal Counsel. There was an article in either New York Times or Washington Post about how that important White House office, or is it in the Department of Justice?
It's DOJ.
DOJ, is basically being ignored. And maybe take just a minute and explain why that is such a travesty.
Yeah, so historically, the Office of Legal Counsel in the Justice Department was basically like the nerdy lawyers for the president. So the White House counsel is like the personal lawyers to the president, but OLC was there to make sure that all of the procedural forms are being followed, and to sort of make sure that the president is, acting consistently with prior presidents, make sure that the right, analyses are being provided to support these decisions. The fact that Trump is bypassing OLC is, I think, for folks who know the processes here, really like the biggest possible red alert klaxon, that this is a president who's not interested in the legal niceties. And this is an administration that doesn't want to actually ask the hard legal questions of the smartest lawyers they have, but would rather, act first and worry about the legal consequences later. I mean, I think, there's a case that the Supreme Court may soon take up, about the president's effort to fire Gwynne Wilcox and Kathy Harris, who are respectively members of the National Labor Relations Board and the Merit Systems Protection Board. And I have that backwards, but those two boards. And the basic question in both of those cases is whether the president can fire members of multi-member headed agencies, not just the NLRB and the MSPB, but the Federal Trade Commission, the Federal Communications Commission, the Securities and Exchange Commission. I mean, all of these agencies that have historically played this critical role in the federal government. And the reason why that matters, Jim, is because one of the agencies that's lurking right behind these agencies is the Fed, the Open Market Committee, the Board of Governors of the Federal Reserve. And I think there's a serious concern that if the Supreme Court lets Trump fire these other folks and holds that the statutes that require good cause for their firing are in fact unconstitutional, then you're going to have a real problem with the possibility that Trump could also fire members of the Federal Reserve Board, at which point you have completely undermined the independence of our central bank. I'm not an economist, I'm a law professor, but there are plenty of economists who would say that central bank independence is actually critical to economic stability. So the Supreme Court undermining that independence, I think, would be yet another blow, right, in the name of the unitary executive theory to actually what has been, at least in the Fed's case, for 110 years, a very well-designed, well-functioning system.
Now, this may be getting into the weeds. Like I said, we might a bit, but what's the difference between a principal officer, which could be an ambassador or a cabinet secretary, and then the strange term inferior officer, or which almost sounds like an essential or non-essential employee?
A principal officer traditionally is someone who actually has an appointment that involves Senate confirmation, and someone who actually has responsibility at a level where they are not serving at the pleasure of the president. An inferior officer is someone where the pleasure of the president is actually what would guide them, and they are not congressionally affirmed. So an ambassador is nominated and confirmed with the advice and consent of the Senate. An NSC employee is not. So the NSC advisor is an inferior, whereas a diplomat is a principal.
I'll just add, I think there's actually, there's one more annoying nuance in the case law, which is there really are three categories of folks in the executive branch. There are principal officers, inferior officers, and employees. So, a line attorney in the Justice Department is an employee who's not covered by the appointments clause at all. Someone who is like the deputy assistant attorney general for national security, they're an inferior officer where Congress doesn't have to require Senate confirmation, but Congress can. And the difference between them and, say, the attorney general is that the deputy assistant isn't making any decisions on behalf of the department, right? That they have authority in that they run, for example, a whole sort of part of a division, but they're not by themselves vested with significant decision-making authority that isn't immediately answerable, immediately accountable to the higher folks. The reason, Jim, why this distinction matters is because, at least for now, there's a 1988 Supreme Court case, Morrison versus Olson, that stands for the proposition that for inferior officers, Congress is allowed to protect them from, from presidential termination, except for cause. but that for principal officers, Congress can't. Like the firing of Gwen Wilcox and Sarah Harris, that precedent, I think, too, is one that's directly implicated by the current court's hostility to the unitary executive, and one that the Supreme Court may well, also want to see on the chopping block.
So what about when the inspectors general were fired shortly after President Trump took office? Where did they fit in? Stephen?
So inspectors general historically have been viewed as inferior officers, that they have significant duties, but they don't actually control, any policymaking on behalf of the departments or agencies they serve in. Jim, some of the inspectors general probably were fired unlawfully in violation of for-cause removal restrictions. But even besides that, Trump himself, right, got behind, helped to inspire a law that Congress enacted a couple of years ago, which requires the president to give Congress 30 days notice before he fires any inspector general. And that was passed by bipartisan majorities of both chambers of Congress during the Biden administration. And suffice it to say, none of that notice was actually provided in these cases. So, again, we have the sort of unitary executive run amok, where even a notice requirement, something that doesn't actually prevent the president from firing these officers, but just requires him to go through a particular process if and when he does so, is being cast aside on the theory that it interferes with the president's atextual Article II power.
So, from where I sit, it looks to me like Congress has really abdicated a lot of its power. Jeremy, you and I have often talked about the authorization to use military force, which was put in place after 9/11 and I think is still in effect. And lots of people say that should be canceled. And so how can Congress be willing? What would it take for Congress to get a backbone?
So I think it will take the president's popularity cratering if the economy continues to crater, and members of Congress recognizing that even though he might be able to challenge them in primaries, they can't win in their, especially statewide elections in the Senate, if he continues on this path. And I think that is already beginning to happen. It's happening too slow, and it's happening on the margins, but we are seeing some small pushback, especially in the Senate. And that's where we would expect it. I think if the president's popularity continues to crater, we'll see more of that. And very specifically, that would mean members of Congress actually legislating to force the president to spend money that they've appropriated, legislating to limit his ability to institute tariffs. There is a legal case, I think, to be made that he has already well overshot his tariff powers. But Congress, with legislation that, of all people, Iowa Senator Chuck Grassley has proposed, Congress could tomorrow severely constrain his ability to institute tariffs of one kind or another. And I think we'll start to see threats and discussions and perhaps even some action in that direction.
Stephen, do you agree with Jeremy on this? I agree that Congress could do all of those things. I'm a little more circumspect about whether it will. But I think there's a larger lesson here. And we alluded briefly to all of these statutes that Congress passed in the immediate aftermath of the Nixon administration, many of which were designed, right, to rein in some of the abuses that Congress had found with regard to President Nixon. Jim, I think one of the things we're learning is that those statutes are okay as long as Congress backs them up when the time comes, but they're pretty toothless otherwise. Meanwhile, the substantive authorities Congress has provided. So, for example, in the International Economic Emergency Powers Act, which is part of the basis for these tariffs, those authorities, Jim, we're seeing more and more evidence every day, need to have sunsets and need to have mandatory sunsets where presidents who want to use those authorities for more than a very brief window of time have to go back to Congress and get Congress to sign on. This was the model for a lot of presidential power in the early republic. I mean, the way that Congress, for example, authorized presidents to use military force domestically during emergencies, something that George Washington followed to the T during the Whiskey Rebellion, had a sunset and said, listen, you can do this until 30 days after Congress is back in session. This at a time when Congress was out of session most of the time. So, I think the real lesson for a world in which you have a Supreme Court that is willing to bless at least much of the unitary executive is for Congress to give less substantive authority to the unitary executive in the first place and to put more aggressive sunsets on the authority it provides, lest they be abused by presidents who are protected by enough support from their party that you can't get veto-proof supermajorities in both chambers to override him.
I think Steve raises an excellent point, Jim, but I also think it takes us back to one of the structural elements of American governance. Throughout our history, more often than not, especially in recent years, we've had Congress of one party and presidents of another party. And one of the reasons that the American public has voted that way consistently is a very rational reason, because it actually provides a protection against what Steve is talking about right now. What we're dealing with now is a party in power that is giving its own president a blank check to some extent. That could change very significantly. It was not that long ago that Congress in a certain way held President Obama hostage, forcing him by refusing to pass a budget or to allow for the debt ceiling to be raised, forcing him to make compromises on many policies he might not have made compromises on.
Thank you
Right,
very
so-
much, gentlemen. Really appreciate you being with us. And with now over 100 cases before the courts questioning whether the Trump administration can take actions, from the firing of agency heads to the impoundment of congressionally appropriated funds to the deportation of individuals, importantly without due process, the guardrails of our democracy are certainly being tested. As we go forward in the coming weeks and months leading up to the midterm election, we'll see if the laws that were designed to prevent the abuse of unchecked power will hold. Thank you so much for watching Perspectives Matter, where we talk about things that matter with people who care.